fellow Kenyans, on several occasions, I have stressed that in its elaborate corruption scheme, this government is out to outrightly rob Kenyans. This is exactly what the repeal of the Privatisation Act 2005 and the enactment of the new Privatisation Act is doing. The new act introduces a privatization process mainly in the hands of the executive through the Treasury Cabinet Secretary and the Privatisation Authority. It grants the CS Treasury power to create a privatization program which may include an unlimited number of public entities earmarked for privatization. Sections 22 and 23 of that Act give the Cabinet Secretary unfettered power to require the National Assembly to ratify its privatization program within 60 days, failing which the process in the next 30 days will automatically proceed without parliamentary approval. Once approved, the program is valid for 8 years. Please note that. Once approved, the process is valid for 8 years. The most outrageous part of this process is that the ratification request is only to be accompanied by brief descriptions of the entities undergoing privatization, brief reasons for privatization, and expected benefits, including expected revenue. Crucially, and this is important, information on the valuation of those public entities is not mandatory to be included in the ratification request by the CS. This is meant to entirely circumvent the necessary elaborate parliamentary oversight and neuter public participation. That's not all. The Act has no provisions built in to ensure parliamentary oversight regarding implementation of a ratified privatization program conducted by the executive. In fact, the Act even exempts publication of the names of the buyers if the privatization is by an initial public offering, IPO. Simply put, if they sell to themselves or their proxies, the Kenyan people will not get to know. Simply put, if they sell even strategic assets to foreigners and put them beyond the country's control, the Kenyan people will not get to know.